Justice has been variously defined, and it is the constant and perpetual disposition to render to every man his due. Or perhaps more correctly, it is a conformity of our actions and wills to the law. 6. Justice is an interior or exterior. First is the conformity of our will, and the last of our actions to the law. The union of both makes perfect justice. The last is alone the subject of human jurisprudence. Interior justice is the object of morality. 7. In the most extensive sense of the word, justice differs but little from virtue, for it includes within itself the whole circle of virtues. Yet, the common distinction between them is this: that which positively and in itself is called virtue, when considered relatively with respect to others, has the name of justice. But justice, being in itself a part of virtue, is confined to things simply good or evil, and consists in a man taking such proportion of them as he ought. 8. To make a law, there must be a superior who has authority to make it, as an inferior who is bound by it. To complete the definition of law, we must say that it is a rule prescribed by a lawful superior. God, as a principle, is the first great superior. Peace and order in society would not be guaranteed by the principles of human legislation if those principles were not protected by the salutary influence of true religion. Now, of course, that's distinguished from dogma. And human laws would be insufficient to regulate the conduct of man if their action was not supported, directed, and supplied by religion and morality, and religion would of themselves be powerless to ensure the peace of society without the aid of the civil law. Many moral obligations exist which are not enforced by the civil law, and these are left to the operations of conscience, and such, for example, as gratitude and benevolence. 9. The law of nature, or natural law, is that which God, the sovereign of the universe, has prescribed to all men, not by any formal promulgation, but by the dictate of right reason alone. It is ascertained by a just consideration of the agreeableness of disagreeableness or disagreeableness of human actions to the nature of man, and it comprehends all the duties we owe either to the Supreme Being, emphasized, to ourselves, emphasized, or to our neighbors, as reverence to God, self-defense, temperance, honor to our parents, benevolence to all, a strict adherence to our engagements, gratitude, and the like. By natural law is also understood the system of collection of those laws arranged together in a methodical order. And the law of nature is superior in obligation to any other. It is binding in all countries and at all times. And no human laws are valid if opposed to this, and all which are binding derive their authority either directly or indirectly from it. 10. The law of nations is a system of rules deducible by human reason from the immutable principles of natural justice and established by universal consent among the civilized nations of the earth in order to decide all disputes and to ensure the observance of good faith and justice in the intercourse which must frequently occur between them, or it depends upon mutual compacts, treaties, leagues, and agreements between separate, free, and independent communities. The law of nations, jus gentium, has of late years been called international law. So when you hear international law, keep in mind the laws of nations, etc., they are conjoined. So nations with regard to each other are considered as individuals, and the law of nations is to regulate the differences which may exist between them in their national capacity. And of course, that would be in what is known as diversity of citizenship or diversity of nationality, i.e., those would be consular venues, and such courts would be largely consular in their nature. Now, they are in a state of nature and must be considered as so many free and independent persons living in that state, and therefore the rules of natural law are to be applied to them. International law is generally divided into two branches: the natural law of nations, consisting of rules of justice applicable to the conduct of states; the positive law of nations, which consists of the voluntary law of nations, derived from the presumed consent of nations, arising out of their general usage; the conventional law of nations, derived from the express consent of the nations as individuals and evidenced in treaties and other international contracts or compacts; the customary law of nations, which is a tacit consent to certain rules which have been observed by them. The law of nations has been divided by writers into necessary or voluntary, or in absolute and arbitrary, by others into primary and secondary, which later has been subdivided into customary and conventional. Another division is made into natural and positive. The various source and evidence of the law of nations are the following: the rules of conduct deducible by reason from the nature of society existing among independent states, which ought to be observed among nations; the adjudications of international tribunals such as prize courts and boards of arbitration; text writers of authority; ordinance or laws of particular states prescribing rules of conduct of their commissioned cruisers and prize tribunals; the history of wars, negotiations, treaties of peace, and other matters relating to the intercourse of nations; treaties of peace, alliance, and commerce, declaring, modifying, and defining the pre-existing international law. That's 11. All right. That should be sufficient at this point. So I want to put you in the state of mind that the fundamental principles of law are based actually in common divine reasoning. If a law or an ens legis execution, and an ens legis is where you have people who claim to be in legislative government, or sometimes wrongfully executing from the bench, where you see people who claim to be judges are making up rules that are contrary to the established law. Those are frauds, etc. And anything that contradicts common sense is not the common law. and 90% of the time is not the law. This is why these fundamentals are being shared with you, so that you can have a fundamental concept of basic principled law, which harmonizes with common sense. If it contradicts common sense, 90% of the time, it's not the law. So let's talk.
I do have a question, though, if you don't mind.
Yeah, come on, let's talk.
You talked about who created or established the law of nations that you speak of in the text.
Basically, the laws of nations is ancient, coming from the ancient Moabites, Canaanites, which you'll find, and also the structures of what is known as the ancient and modern principles of jurisprudence was formulated in Asia and Africa, and was promoted for the world, or coming out through trade, etc., through Iberia. And so the word Iber or Uber means the highest or the noblest. So when you hear the word Iber or Uber, it comes from ancient Iberia, or the ancient central point of the Picts, the Moors, and the Dubs, and you are known them now as the original Aboriginal Europeans.
That's interesting.
So usually you will say, they will teach, when they're teaching law or principles of law, they will say the principles of jurisprudence coming from England, without qualifying that it's Uber, Iberia, yes, i.e. Moors. They're the founders of the principles of civilization. And so when you're dealing with jurisprudence is a science that treats of positive law based in nature's law and nature's God, comes from ancient Africa, and has been spread around the world among nations, and manifests itself today as ancient and modern jurisprudence. And the nature of this is found in the principles of treaties and constitutions aligned with nature's law and common sense and fairness, and the nature of the higher self, distinguished from principles of lower self.
I got it. All right. But the law itself that you're reading from is that being used in what government?
All right, this is basically American law. So when you talk in American law, it's important for you to know who the Americans are, which is also why I read that earlier, because people keep assuming that Americans are the hybrid Europeans that have been occupying North America for the last couple hundred years. The principles of constitutional order has no origin with them. It has origin with the Africans, i.e., loosely referred to as the Phoenicians.
I guess I have to ask the question, and some might say, if we had established laws and all these tenets, and if things come from our laws, how did we get out from under our own established laws?
Ignorance, and you've been conquered. Now this goes back to also what I presented earlier. Those of you who have been sharing with us here at the House of Reawakening Minds, you're reminded in satisfaction to your question to go quickly into your phone or into your computer and look up the philosophy page of the General Education Board, and that will tell you much right there. Because most of our people have been so-called educated by members of the Board of Education, whether they've been the hybrid Europeans or people who have been participating with them, who are among our own. And they have been actually participants and proponents of actually the mind control systems and the animal husbandry that our people are suffering from in the name of education, and thus also with us violating our ancient principles, and also from being conquered have lost context with the consciousness of our true Sabian culture, and therefore we have fallen away from the principles of government and thus become subject to occupational powers of the conquerors under the Spanish Inquisition, known as the unum sanctum operations of the popes of Rome, who took over Roma. So when you do research, you'll know the distinction between Roma, Africa, and Rome, the hybrid Europeans. This is why I also reference to many of you, if you would like to have a better comprehension of the nature of modern political operations, particularly in the Western Hemisphere, do some research in the Napoleonic Wars, and then make some reference to when the hybrid Europeans took over the African popes and rulers of the ancient world and reconstructed the history which you have been receiving. And all of this conjoined has much to do as to how we fell away or lost knowledge of true culture. It's not hard to find. But particularly, again, while we're talking about this, is to, with the intention of mentally liberating or helping to liberate many of our people from the parasites who are closest to us. See, because like like they say, you can't get at the big octopus. What you can do is start reducing the tentacles that are wrapped around you. And that is these fakers, parasitic people around you who have came into the Moorish movement for the sole purpose of making a revenue stream for themselves, not for really liberating our people. Get rid of them first, and then you can get to the head of the octopus. And it will be done spiritually and with consciousness. So once you have a comprehension of what should be, you absolutely know what shouldn't be. And also this is relative to, over the years, you recognize some people just appear not to get or to be able to cognate and to wrap their heads around that which is de facto distinguished from that which is de jure. While we've had these conversations for years, you'll see some of the questions that arise among the people is that concept is not clear with them, which is again why we're having this short treatise tonight on the matters of American law, that they have contributed actually to the occupational hybrid Europeans. You must know it actually came from your forefathers. It was adopted by them so that they could have structured government, but those principles did not originate with the hybrid Europeans. They originated with the Moors. So don't reject them, as some people have been telling you. Oh, those constitutional principles don't apply to you. Those allodial principles don't apply to you. Yes, they absolutely do.
His question. Would you take the question? This question says, can any of our, I'm not sure what it is, can any of our Moorish sovereign power protect us from the V mandate the de facto has in place?
Yes. Well, this is back to, as many of you know who have shared years ago with us with the Roundtable, and also who've been sharing with us on the House of Reawakening Minds, one of the methodologies that I've been using over the years that has angered many people among our own as well as the hybrid Europeans is I've been doing or presenting writs and concepts with our people that actually are directed to the people reclaiming their divine self or their divine sovereign right. In doing so, they are actually psychologically firing the so-called public servants, i.e., or making them irrelevant. In the process, it has made them respond or force their hand to openly suppressing the people, and by virtue of that, exposing themselves. And then by virtue of the people recognizing that these people are not their government and have not been actually serving them, but actually been serving themselves at the expense of the people, and to the injury of the people, that state of mind is necessary for our people to willingly render unto Caesar what is Caesar's, or give back to Rome the false concepts that Rome has promoted and the fakery that they have been operating under, pretending to be your government, and to turn back to those principles of your ancient mothers and fathers of jurisprudence. And in doing so, you will be empowered, going back to your quote unquote God self, and therefore they would have no power over you. And so they recognize that that this is really the chess move I was making on a fifth dimensional plane, which is many of them don't like me. That's on both sides.
So there is a the Senate Bill 942 that has an exemption, and where one can do an affidavit. Now I know I did get a copy of that based on something that's already in their records and so forth, and you just got to give back to them what they put out, and I guess they bank on most people not knowing.
Now, isn't it even the fact that that would be presented as an issue before the people shows you that they have been deceiving the people and negligent, because the people should have already known those things, shouldn't they?
Yeah. So
because that's called established law, isn't it?
Absolutely.
So that means they have not been operating on established law, doesn't it? So that means they were knowingly defrauding the people, haven't they been?
Right.
So when people become active, what does it do? It forces their hand and exposes them, and therefore they have to justify what they have been doing, distinguish from what they have not been doing. And in the process, it also exposes the opportunists that have been among our own too, doesn't it?
Right.
Well, that's why we're having this conversation.
But I'll be happy, this was sent to me. It needs a little cleaning up, just grammatically, but definitely would make it available. And I think, thank Brother Truth for that document. And but I just need to clean it up just a little bit grammatically. But it's based on the established law,
which means that's the law.
There's the law.
See, so if it's not that, it's not the law, is it?
True.
So we've been living under a lawless regime, thinking that they were government, haven't we?
Yes.
And we've been paying taxes to them, mandatory under the guise of voluntary, haven't we? Which is absolute contradiction, isn't it?
Absolutely.
So we have been operating or serving a criminal organization of parasitic exploiters, thinking they were legitimate government, but the people believed in them, didn't they? Mm-hmm. This is why a lot of the processes or things that I've been saying over the years I've done or said or produced, but I also told the people, and I always qualified it by saying some of the things we're doing now will not be doing later. Why? Those were chess moves to force